Okay, so, all right, this is, as I said, an estate planning program for writers. There are some specific things that writers need to know about estate planning that I think will help. I am an attorney. I do entertainment law, estate planning, author law, real estate, corporate, and copyright. I'm a commercially produced playwright. I'm a theater producer. I've founded a couple of theater companies. I've been a member of the Authors Guild since 2002. And I've written books on theater law and for non-lawyers. There's one of my books on there now, and there's another one of my books. And the next thing is I want to have a legal disclaimer that this is for educational purposes only. It's not intended to be advice about specific legal issues. And we're not creating an attorney-client relationship with any of you. And my recommendation is if you have a specific legal matter to consult with an attorney of your choice. We got the legal disclaimer out of the way there. So first of all, let me suggest that there's a lot of material that I'm going to go through, and it won't apply to everybody. And you probably won't remember it all, but what I would think will benefit you the most is while we're going through everything, if you think about your own personal situation, your assets, including your copyrights, the form in which you own your assets, your liabilities, your family, your friends, your charities, potential beneficiaries and heirs, and whether any of your beneficiaries or heirs might have special needs, your pets. Sometimes people forget that their pets might outlive them. And so people don't necessarily think about taking care of their pets after they pass away. How do you want your property to pass on your death? What if you become disabled and you're still alive, but you're unable to manage your own affairs? Of course, there's your artistic legacy. And how do you want your intellectual property to be managed after your death, or in the case of your disability? This is not a complete list. There's certainly a lot of other issues to talk about, but again, this is a start. I'm not going to talk about estate or inheritance taxes tonight because, again, there's a lot of material there. And the way estate and inheritance taxes are today with the exemptions and all, chances are probably a lot of you won't even have to deal with that. So you should wish you were in that position where you have to worry about estate taxes. But so I'm not going to talk about any of that tonight. But I am going to talk about the estate planning problems for owners of copyrights. A lot of estate planning specialists don't know how to handle copyrights and internet and IP and estate planning because copyrights and trademarks require specialized knowledge. And there's no states that specifically deal with copyright in their probate and their estate administration laws. There's very few judicial opinions that give us any kind of guidance. In fact, most of the judicial opinions on that deal with copyright usually involve copyright infringement suits, and they don't talk about estate planning itself and the estates of the writers, other than it may be the estate that is filing the suit for infringement, like for example, the Dr. Seuss estate is very aggressive about suing infringers. The William Faulkner estate just sued Sony Pictures over claiming that Sony Pictures made a movie that infringed on the copyright of a book that Faulkner wrote in 1950. And so it's mostly all copyright infringement cases that that the courts usually deal with. So there's very little judicial opinions that help us. There's very little literature on the subject. U.S. Copyright Office is of no help whatsoever. And as we know, copyrights and trademarks can last for a long time after the owner passes away. And a lot of beneficiaries don't know how to manage inherited copyright for its maximum value over the lengthy time that it remains in effect. But yet, the thing about it is that with copyrights, I mean, they go on a long, long time, and heirs and beneficiaries can benefit from them for for years and be making money from them, and also preserving the artistic legacy of the author, which is important to all of us, that we want to make sure that after we die that nothing tarnishes our artistic vision. And there's ways of doing that with proper estate planning. And I'm going to try to show you some of those techniques tonight. Now, we know copyright lasts for the author's life plus 70 years. Let's say, for example, Jack writes a book called The Ghost of Elsinore Castle. He registers the book with the Copyright Office on March 22nd, 2022. He's 40 years old. He passes away March 22nd, 2062. His copyright lasts for 70 years after March 22nd, 2062. His heirs benefit from the copyright until March 23rd, 2132. That's a long period of time to be able to get benefits from his copyright. And if he has collaborated with someone on writing a book, let's say he collaborated with Jill in writing The Ghost of Elsinore Castle. Again, we've got the same facts, but now Jill is 30 years old, and Jill doesn't pass away until December 31st, 2082. The copyright lasts until 70 years after her death, because the copyright continues until copyright lasts for 70 years until after the death of the last surviving author. So the copyright on The Ghost of Elsinore Castle would last until January 1st, 2153, which is 70 years after Jill's death and 91 years after Jack's death. So both of their heirs continue to benefit from the copyright for a long, long period of time. So that's why it's important to think about this. This is being recorded right now, Sandra. So I'm just letting you know, it's being recorded by the Authors Guild. And anyway, works made for hire now is a different story, because unless there's an agreement to the contrary, the employer owns the copyright. And the duration of copyright on a work made for hire is 95 years from the date of publication, or 120 years from the date of creation, whichever expires first. Termination provisions, and we'll get into that in a second about the copyright law, don't apply to works for hire. And since the employer owns the copyright, it's not part of the creator's estate, so it's not part of his planning. So we don't have to deal with that. But that's just something I'm letting you know, because some of you do write works for hire. Trademarks now can last indefinitely. Trademarks may never expire. Federally registered trademarks have an initial term of 10 years, but the owner can continue to renew the registration for 10-year periods for an indefinite period of time, as long as the owner pays a fee and proves he's used the trademark continually in the United States. Look at Coca-Cola. Coca-Cola has been around since the 1880s, 1890s, and it's still under trademark. And here's an interesting thing that I've found out, that some authors may actually own trademarks and brands that they don't know that they own. So I'm going to toss out a question to some of you to think about for yourselves, and what kind of works you do. Do you own an unregistered trademark or a brand that might be potentially valuable, potentially for years? Anyway, but IP needs continual management, because royalties, somebody's got to collect the royalties and audit them. Somebody's got to licensing all the various rights that the copyright laws give us. Somebody's got to defend if there's infringement claims. Somebody's got to enforce the copyright against infringers, like I just used the examples of the Dr. Seuss estate and the Faulkner estate. There's always new markets and new technologies that are opening up for IP. Somebody's got to authorize new editions or sequels or prequels. After the original author passes away, there might be chances to update the books with new editions. And somebody's got to exercise the termination rights. And again, somebody's got to preserve the author's legacy and artistic vision. And if there's a collaborator, all of these have to be coordinated with the collaborator's estate. So there's a lot involved with continuing managing these copyrights long after people have passed away. Now, copyright termination rights, some of you may know about this, some of you may not. Copyright law recognizes that sometimes authors, especially when they're just beginning their careers, they'll sign contracts with that are not all that favorable to them. They'll sign contracts that are, of course, more favorable to the publisher. But as we know, books can become bestsellers, authors can become names, and those initial contracts that the authors have signed that have unfavorable terms to them, well, the authors will not be too happy about them, and they may want to, at some point, they may want to renegotiate those contracts or shop the book around to another publisher that will offer them better terms. So the copyright law has recognized that, and so if you've got a book that a copyright, an agreement or a license that was entered into January 1st, 1978 or later, after 35 years, there's a 5-year window in which you can tell the publisher that you want to terminate the contract, and then if it's valuable or not to the publisher may be willing to renegotiate. Or if you've got a valuable property, you might be able to take it somewhere else and get better terms. Now, for many of us, we're going to be gone when that happens. But our heirs, the termination rights are passed to our heirs. So our heirs may be able to do something like that, especially if the book is like a perennial. And that does happen, as we know. Okay, now some authors have incorporated for taxes or other considerations, and they have their copyrights titled to their corporation, and that's fine. That's a perfectly good planning method, and I actually recommend that for some authors. But for authors who have done that, who have a corporation, it may require a special estate planning, and I'm not going to get into that because, again, that's a little bit too much to get into for what we're doing here today. But and it needs to be done on a case-by-case basis anyway. Now, nobody can predict the future. We don't know what the future is going to hold for 70 years from now. Like, for example, who would have predicted ebooks, audiobooks, print on demand? Now we've got deep-pocketed streaming platforms that are buying all kinds of material for whether it's fiction, nonfiction, and they're doing all kinds of things with it, and they want to buy material. So there's a potential stream of money there, and of course there's back and print services. So we don't know what's going to happen in the future and what kind of new markets or what new technologies might be in the future. So it's essential that we make sure that our beneficiaries, our heirs, will benefit from whatever those opportunities might be. And of course, we want to benefit from them in our lifetime, assuming that anything like that happens in our lifetime. So like Jack and Jill, they want their copyright to pass to their respective heirs. But here's the thing, if they don't plan their individual estates, the state will choose their heirs by what's called the law of descent and distribution. In some places, it's also called the law of succession. And the state's choices may not necessarily be Jack and Jill's choices. In fact, the state may pass their copyright to people they would not want to own any of their property. And the state's choices may not know how to manage IP. So basically, as I said, if an owner dies without specifying in a will or a trust or other estate planning, it passes to whoever that the state has in their laws of descent and distribution. So the state decides who the heirs and the shares might be that they receive, which may not be what the owner wants. State law doesn't make any provisions if people want to make a bequest to charities. State law doesn't make any provisions for the care of a person's pet after he dies. In most cases, these states have to go through probate. There's no provisions to make bequests to friends or other third parties. There's no provisions for personal property. If you want to leave your jewelry to somebody or maybe a family heirloom to somebody, under state law, there's no specific provisions for that. So, and then the probate court might appoint a stranger to administer the estate. So that's why it's important to do your own estate planning. Now, you're going to hear some words called, there's testate and there's intestate. testacy and intestacy. If you died without a will, you died intestate. If you have a will, you died testate. And I'm tossing out because that is something you're going to hear a lot about when you're going on your own estate planning journey. Now, wills are created by a testator. Now, in a will, a testator designates his executor who will administer his estate. He sets out the instructions for how he wants the executor to administer his estate. Now, in this case, he can bequeath his property in any way he wants to whatever persons or charities or other organizations that he wants to receive his property, and in whatever shares he wants them to receive it. He can also waive an executor's bond. When an executor is appointed by the court, unless the bond is waived, the executor has to put up a surety bond with the court. And that can get expensive. So most people in their wills just waive the executor's bond. If he has minors or disabled heirs, he can designate the people that he would prefer to act as guardians of those minors and disabled heirs. He can establish a testamentary trust, which we're going to get to. A will has to be filed within 30 days of the person's death with the clerk of the probate court. It becomes public information. Anybody can read it. Anybody can obtain copies. And a will is not effective until the testator dies. Until he dies, he can revoke it. He can modify it. He can change it. He can disinherit people in the will. But here's the problem, too, that wills can be contested. And if there's a will contest, it can delay the distribution of the assets, and it can delay the closing of the estate for years, and it can be expensive. Will is not automatically valid. Court has to decide that it is valid. And once an estate has been administered, the will is usually completed. But a trust can go on for decades, and we're going to get into trust because trusts are my favorite type of estate planning, especially for dealing with copyrights and other IP. But I'm just letting you know about a will. Now, probate administration is established by law. It's the legal process by which a person's estate is administered after his death, or if he requires a guardianship during life. The executor or the personal representative collects his assets, pays the estate's debts, and distributes the property to the heirs. There's two kinds of administration. One is a supervised administration, in which the executor and the representative has to go to court every time he wants to do anything. Independent or unsupervised administration allows the executor to make most decisions without the necessity of going to court every time he wants to do something. Probate can be completed within months, but if there's a contest, it may take years. And as I said, it becomes public information. So it's not only financial affairs, but also the family secrets that your nosy neighbors, nosy friends, and even identity thieves can find out. And it can be expensive. And most people want to avoid probate because of these various reasons. So it's just something, again, to think about. Now, I'm not going to go through this whole list of the personal representative's duties, but as you can see, this is what an executor of an estate has to do. These are the minimum number of duties that the executor has to do if the estate has to go through probate. So you can see it's an awful lot of duties that the executor has to go through and do, and that's why it can take time and it can cost money. And again, as I said, it becomes public information. Now, here's something interesting. The living may also need probate. Probate court has jurisdiction over minors, but it also has jurisdiction over adults who are 18 years of older who become disabled and they're not able to manage their own affairs. Like, for example, there's mental deterioration, physical incapacity, mental illness, addictions to drugs, disabilities. And the thing of it is, this can happen to any of us. We could be in perfect health today, and tomorrow we could have an accident, we can have an illness, we can have dementia. I just learned this past week A friend of mine who's only 51 years old is in the early stages of Alzheimer's. And so there's no age limit to when that can happen. So it's important to think about these things now, not just for our deaths, but also for in case something happens while we're still alive. And so that's why it's important to do some serious planning. Now, there's several kinds of guardians that can occur. There's a guardian of the person is when a disabled person can't make decisions regarding his personal care. The probate court will appoint a guardian who may not necessarily be a family member, could be a public guardian. The guardian will manage the medical treatment, social services. He may make choices that the disabled person wouldn't have wanted. He's entitled to a fee out of the disabled person's estate. It's time consuming. And there's there's several kinds of guardians. There's a limited guardian when the disabled person can make some, but not all of his decisions about his person. His powers are specified by the court. The plenary guardian is appointed when the disabled person can't make all of the important decisions about his personal care. The plenary guardian is empowered to make all decisions regarding personal care, which again may not necessarily be the decisions the disabled person may have wanted. And a temporary guardianship occurs if there's an emergency and the temporary guardian is appointed for no longer than 60 days. Successor guardians are appointed because if something happens to the initial guardian is a person. So the initial guardian can become disabled or resign or not be willing to carry on the duties anymore. So the courts will appoint a successor guardian. If there's parents of a disabled person may designate someone to serve as a guardian if a parent dies, but that still needs court approval. The court may not necessarily approve the parent's choice and instead may appoint somebody else. Now, a guardian of the estate manages the financial affairs for the disabled person. It may not necessarily be the same person as the guardian of the person. Again, the court makes the appointment. The court may handle the personal. The court may not necessarily appoint a person that the disabled person would want, and the court may appoint a public guardian. The guardian is subject to court supervision. And again, we've got several kinds of guardians here: the limited guardian, the plenary guardian, the temporary guardian, and the successor guardian, and the testamentary guardian. So that happens when a person can't manage his personal affairs. So now the guardianship problem for owners of copyrights is that guardians may not know how to manage copyrights and other IP. So you may get a guardian even while you're alive, if again you're disabled for one reason or another, who may have no idea how to manage your copyrights and deal with your publishers and your agents, or how to just manage your copyrights. So now there are several ways to avoid probate. One is called a small estates affidavit, and it's limited to probate assets of $100,000 or less. It does not include real estate. It does not include many other things. Now, copyrights, it can include copyrights, but copyrights are not easily valued because nobody really knows what the value of a copyright can be, especially during the future. So copyrights, I mean, technically speaking, you might be able to squeeze them through a small estates affidavit, but it's pretty difficult to do. And there may be probate might be required if previously unknown heirs or creditors come forward. Now, other non-probate assets, now many people own property is in joint tenancy. But the problem with the joint tenant is that the way joint tenancy works is if you own let's say a property is joint tenant with your spouse, for example, and you pass away, your spouse will inherit it automatically by operation of law. But when your spouse passes away, then probate might be necessary for the spouse's estate. Tenancy by the entirety is available only for real estate owned by spouses. There are payable on death accounts with banks and stockbrokers, and many people have those. There are accounts with a named beneficiary, like life insurance, for example. Trust-owned property, we're going to get into that very shortly. And now there's also land trusts. A land trust is an arrangement for people who have real estate, for example, a personal residence. They set up a contract with a trustee where they deed the real estate to the trustee for the benefit of themselves and their named beneficiaries. It does not affect copyrights or any other property or bank accounts or anything. Basically, what happens is that the owner transfers the title to a trustee who becomes the legal owner of the property. The owner and any persons it names in the trust become equitable owners of the property. They have equitable interest in the property. It's created by a written agreement, which is called a trust agreement. That agreement is private between the owner and the trustee and the beneficiaries, unless there's a court order, which rarely happens. The public records will show that the trustee is now the owner of the property, which is a good thing for privacy. It helps to avoid identity theft too. And it also, again, this helps to avoid your private information from becoming public. Now during your lifetime, you can continue to manage the property just as you would. You could sell it, you can mortgage it, you can rent it out, you can do anything with it. You can revoke or you can modify the trust. And if you want to sell the property to someone, or you want to take out a mortgage, you can issue what's called a letter of direction to the trustee. The trustee will execute the documents of sale or mortgage and on your direction. Now, there are fees, of course. The trustee charges a fee for accepting the property. He charges a fee for holding it, and they charge a fee for any additional services like preparing or executing the documents of conveyance. Trustees' fees are not that high. They're usually not more than a few $100s for accepting the fee, for accepting the property. The holding fee is usually only a couple $100s, so it's not very expensive to do something like that. The trustee can be a person, but many people establish land trusts with banks or trust companies that are especially set up for that purpose. And most banks do have trust companies. And here's the other beautiful thing about it is that you don't have to, the real estate does not have to go through probate. When the grantor dies, the beneficiaries only have to present a death certificate to the trustee to transfer ownership to themselves. And then the ownership passes according to whatever terms are in the trust agreement. So if the owner wants his property to go to, let's say his children, his adult children, all it has to happen, he establishes that in the trust agreement with the trustee. And then when he passes away, the children just have to go and present a death certificate to the trustee, and the trustee transfers ownership to them, and then they can do whatever they would want with it, to sell it or mortgage it themselves or live in it or whatever. So there's no probate, and it's very quick and very simple to do something like that. There's something called a transfer on death deed that you may have heard about. It's a probate avoidance tool. It's less complex to create than a living trust, and we're going to get into living trusts too. Again, it's revocable. It protects the beneficiaries from creditors, because the beneficiaries don't have any interest in the property until the owner dies. It's revocable. The owner can change his mind. It doesn't avoid estate taxes. Probate can still be necessary if the beneficiary predeceases the owner. If there's two or more owners, the transfer can become complicated, because if the first owner passes away, the second owner can make changes in the transfer on death deed to transfer the property to somebody else on his or her death, which may not be what the first person wanted. It doesn't apply to copyrights and trademarks. As I said, it applies only to real estate. So and only residential real estate, condominiums, and agricultural land of 40 acres or less with an improved family residence. So it's a very limited tool. Some people do want it because they figure it's the cheapest way to do something. I don't recommend it because it has very little flexibility to it, as you can probably see. Okay, now there's a power of attorney for property. Now, with a written power of attorney for property, you appoint an attorney, in fact, to manage your financial affairs if you're unable to do so. So this is where you are appointing somebody to take care of your financial affairs instead of the court appointing somebody. And you can specify the scope of your attorney, in fact, powers to deal with your assets or bills or your debts during your incapacity. You can make it as broad as you want, or you can limit the attorney in fact's powers. You just have to be specific about what you want to do. And with the power of attorney, your attorney can go to your bank or other third parties, which has to recognize his authority to act in your place. You can state when it's going to begin. So, for example, if you create a power of attorney today, it may not begin until you're ill or you have an injury where somebody needs to stand in your place. You can also specify when the attorney in fact's authority ends. So again, that can be any date you wish. It automatically expires on your death. So you need to have some kind of planning for after you pass away. Most of the clauses in the statutory form are fill in the blank, but the language has to be carefully drafted to reflect what you want. The attorney can be anyone 18 years or older. And again, it's your choice. It's not the probate's court. I always recommend appointing a successor because, again, you've got the issue of something could happen to the attorney, in fact, to your first choice. And so you need somebody to take over for your attorney. In fact, it's revocable. So if anytime you want to change your mind or you want to amend it, or if you want to change attorneys in fact, you can do it. You need to sign it in front of one witness. I recommend two because some states require two, and it's just better to have two. It has to be notarized. The notary can't be a witness. Now, the statutory form does not contain provisions for copyrights and other intellectual property, but you can, with careful drafting, you can include them in the power of attorney form if you want to. And you can also have separate powers of attorneys for your non-financial affairs, like let's say your bank accounts, and another power of attorney for your copyrights. And your attorney, in fact, if you're going to have appoint an attorney, in fact, for your IP, you should have somebody, again, who's got knowledge of how to manage IP. And so, again, the beauty of the power of attorney for property is it takes your financial affairs out of the probate courts. So it's a very good a very good tool to avoid probate. Now, you can also have a power of attorney for healthcare, because remember I said that if you become disabled or where you're not able to manage your own medical or affairs and make decisions, you can have a power of attorney. You can appoint someone to manage your medical treatments if you're not able to and make decisions for you. And again, it should be somebody that you appoint who has some knowledge about medical care and who understands your wishes, so they can deal with the doctors and hospitals. And the doctors and the hospitals, they have to respect your power of attorney. As long as it's properly drawn, they have to respect your power of attorney. So if let's say if you're ill and you're let's say just the most extreme example, you're in a coma and you can't make your decisions, the third parties, the doctors, the hospitals, they have to respect whatever you have put in your power of attorney, and whatever your power of attorney, your attorney, in fact, tells them to do, which should be what you want to be done. Now, and you can specify when the authority ends. So, for example, it can be a limited power of attorney It's only supposed to happen while you're ill. And if you recover, then the power of attorney can be revoked, and you're back to managing your own affairs yourself, and you're making your own medical decisions. Again, I recommend appointing a successor attorney. In fact, it has to be signed, and again, 2 witnesses. A notary is optional. I do recommend giving copies to your doctors and your dentists and any other regular healthcare providers, so they've got it on file just in case that they might need it, and you're in that situation. Okay, now there's a declaration for living will. The living will says that in the living will, you're saying you don't want your death to be artificially postponed. So if the attending physician personally examines you and determines that death is imminent, unless your death is prolonged by delaying procedures, you can direct that you just want to die a natural death, and you only want the doctor to give and the hospitals to give you whatever medication and food and water and painkillers, for example, that will keep you comfortable during the dying process. And it's used, of course, if you're not able to give directions yourself. Again, the family, your physicians, your hospitals, they have to respect your declaration for living will. It doesn't have to be notarized. It doesn't have to have witnesses. Again, I recommend it just so that there's no question that you've done this, you've created the living will according to whatever you really wanted to say, and so that there's no way people will try to contest it, and that you were in your right mind when you created the living will. Now, disposition of anatomical remains, this is more comprehensive than those basic little donor cards you get from the Secretary of State. I want to donate my body to or my organs. This, you can say that you don't want any gifts of your body or its parts to be made, or you can specify organs or tissues that you want to be donated. You can give your entire body. You can specify the reason for or the use for your body or the organs, like transplants or therapy or medical research or education. And you can impose any limitations or special wishes that you want. But again, you can just say no gifts at all of any of your parts. Now, trust, this is my favorite because they really do a great job of avoiding probate. And I consider them the most useful estate planning tools. You can transfer ownership of your present copyrights and other intellectual property into most of them. They can own your future copyrights too. And now there's 3 parties to a trust. There's the settlor, or sometimes called the grantor, or the donor who creates the trust and funds it with property. The trustee is the legal owner of the property. Remember our discussion about land trusts? And there can be more than one trustee, so you can have co-trustees. The beneficiary is the equitable owner of the trust. And again, there can be many beneficiaries. You can have the settlor, the donor, the grantor can also be both a trustee and a beneficiary. And usually is. It's usually the settlor, the donor, and the grantor is often the initial trustee and the initial beneficiary. And now the benefits, it avoids probate except testamentary trusts, and we'll talk about that shortly. It's private. Again, the terms are known only to the settlor, the trustee, and the beneficiaries. The corpus, which is the property that's in the trust, that's also private too. Remember I said in probate court, all your financial affairs become public information, not with a trust. With a trust, whatever your financial affairs, whether you've got 50 cents or $50 million, it's all private. Nobody knows what it is. Disinherited properties are not entitled to copies of the trust agreement, which makes it harder for people that you want to disinherit for them to contest the trust. Minors can't receive the money outright, but trustees can create trust, but the trustees can pay for their needs, or their care, or their education. Trusts can permit gradual distributions of property instead of giving it all at one time. You can give it all at one time to a beneficiary, or you can do it gradually. Let's say, for example, you've got a daughter and you want to give her, let's say 10% of the trust property when she's 18, and maybe when she's 25, you want to give her another 20%. When she's 30, you want to give her the rest of the trust. you can do that. You can set it up any way you want, any kind of distribution you want, or you can give it to her, give it all to her. There's tax benefits. Literary trusts, which we're going to have a long discussion on shortly, will provide for the management of copyrights and other intellectual property. And like I said, probate distributions can take months or even years. Trust property can be distributed immediately on the settler's death, unless the trust agreement calls for gradual distribution, like I noted above. A spendthrift trust can protect a beneficiary's share from his creditors. A trust can also protect a beneficiary from spending his share on gambling or drug addictions, or if he just doesn't know how to spend money, for example, and he just would go squandering. That's why, that may be why you might want to have a gradual distribution of the property, or if you've got somebody like that. So basically, these are the differences. This little chart shows the differences between a will and a trust. You can see that there are a lot of benefits to trust as opposed to a will. That's why I prefer trusts over wills and why I recommend them. That doesn't mean people don't do wills, or I would discourage people from doing wills if that's what they really want. But I just feel that trusts are the better way for most people to go. And most people are doing trusts these days, by the way, because of all the benefits. Now, you're going to hear the words inter vivos and a living trust. An inter vivos and a living trust is the same thing. It's a trust that's created during the owner's life. That's all it is. It's not anything magical. It's just you create the trust during your life. And so sometimes it's called an inter vivos trust. Some people call it a living trust. Same thing. Now, inter vivos trusts exist immediately after you sign them, but you need to fund the trust for it to be effective, because otherwise it's like going to the bank and you open a bank account and you don't put $1 into the account. So there's nothing there. There's just an empty bank account. And inter vivos trusts can exist for decades, which make them ideal for copyrights and trademarks. A testamentary trust, that's subject to probate, and that's created by a will, and it's revocable, and it can be amended until the testator dies. It's irrevocable once the testator dies, and it can't be amended. Obviously, the testator is not there anymore to revoke it or amend it. Now, it does not take effect until the testator dies. The will is amended to probate, and a judge declares the will is valid. It becomes public information, like all of the probate proceedings. And again, it has to be funded like all trusts. And you can transfer copyrights and other intellectual property into testamentary trusts. Now, as I said, wills and testamentary trusts are only effective after the testator dies. And I know I'm repeating some of this material, but I'm doing it for a point because I want to make sure that it's clearly understood, and I hope it will be. So wills and testamentary trusts are ineffective until the testator dies, the will is probated, and the court declares it's valid. The court will issue letters testamentary for wills, which is the letters of office for the personal representative. If you created a testamentary trust in your will, then the court will issue letters of trusteeship, which is basically a court order appointing the trustee to manage the testamentary trust. The wills remain in effect until probate is finished. And testamentary trusts do continue for decades. The difference between them, though, and inter vivos trusts are, as I said, that they become public information, and you may not want that. Now, a revocable trust, that's the most popular type of trust because it's got so much flexibility to it. Anytime during the grantor's life, he can revoke it, he can amend it, he can modify it, he can add property to it, he can remove it. It's not a separate tax entity, so it uses the grantor's tax ID number. It usually doesn't offer any tax benefits. It's ideal for copyrights because, again, it lasts for decades, so it can last for the duration of the copyright. Now, once the grantor dies, then it becomes irrevocable. Again, it avoids probate, and again, it's private. It's hard to contest, And the trustee can be a natural person or a business. There are businesses that, will act as trustees. And of course, they charge fees for their work. Irrevocable trusts can be useful for some purposes. Once they're created, they can't be revoked, modified, or amended by the settlor. That's why they're called irrevocable trusts. Now, except under certain circumstances, the trustee or all of the current adult beneficiaries may be able to go to court and get a court order to revoke the trust. That rarely happens. Courts rarely revoke irrevocable trusts. Now, the thing is, the difference between the irrevocable trust and the revocable trust is that once you transfer property into it, the property can't be removed. And similarly, if you can't add new property to it, it becomes a separate entity. And so it requires a separate tax ID number. And it removes the value of the property from the estate, which is where you might have some substantial estate tax benefits. Again, if you've got an estate that's subject to estate taxes. Now, ownership of copyrights can be transferred into it. It requires the trustee, and I recommend a successor trustee. It might be useful if you've got any beneficiaries who are receiving needs-based aid from government programs. It can be a useful protection against creditors of the settlor and the beneficiaries. And again, it avoids probate. Now, if you've got beneficiaries who may be on needs-based government programs, like Medicaid or supplemental Social Security income, maybe you want to provide them with some additional income. And you can do that if you set up an irrevocable trust, but you have to be very, very careful about what you do, because all those government programs have limits on the amount of income that the beneficiaries can receive from them. And if the beneficiary receives too much income, the government program can either confiscate the trust, or they can just cut the beneficiary off from the program altogether. So you don't necessarily want to, so you probably don't want to do that. And that's why it's an open question of whether you want to transfer your copyrights into the kind of trust, because you don't know what the future value of the income from the copyrights is going to be. And you don't want to do something that might at some point cost your beneficiary the needs-based government program. Of course, on the other hand, if your copyright creates a tremendous amount of income, your beneficiary won't need the government program anymore. They'll have the copyright income. But again, that can be unreliable depending on what the future holds. Now, the types of trusts include special needs trusts, supplemental needs trust, income-only trusts, Medicaid asset trusts, and pooled income trusts. I'm not going to go into all of that, because again, some of those could be subjects for webinars by themselves. And when you're doing your estate planning, you don't want to forget your digital assets, because today, almost all of us have digital assets of some kind. So social media companies might require your fiduciary to be able to take control and management of your social accounts. Also, most of us have online financial accounts with banks, brokerages, and so forth. We may have online bill paying. We might own online businesses. We might have cryptocurrency. Some of us have self-published ebooks. And so somebody's got to administer all of that. And so it's a wise idea in today's world to make sure that you account for your digital assets in your estate planning, so that your administrator can access and manage your accounts, whether it's to close them out or do whatever with them. But it's important to make sure that somebody has the authority to access those accounts. So don't forget those when you do your planning. Now, pet trusts. Pet trusts are interesting because most people don't usually think about their pets when they're planning their estates, because sometimes but pets sometimes can outlive people, as we know. And without a trust, pets can face the risk of being mistreated or used in scientific experiments or euthanasia if the owner dies or becomes disabled. And a pet under the law is treated like any other property, like a sofa or a table. And there's no provisions in the law for its care. So most states provide, though, and that an owner can create a trust for his pet. So the owner can make sure that when he passes away or if he becomes disabled, the pet will receive a certain desired standard of care, like for example, being taken to the vet that the owner and the pet know and trust, its favorite foods, its physical challenges, and so forth. And you can't always necessarily rely on a family or friends to provide the continual or proper level of care for a pet, and pets can cost money, as we know. So pets are not legal beneficiaries. They can't directly inherit money, but you can establish a trust in which you fund it with some money, so that the guardian can be appointed to take care of your pet if you pass away, and there'll be money to give the pet the standard of care that you want your pet to have. Now, there's limitations on the amount of money that you can leave to the trustee for the pet's care. So, again, that's a case-by-case basis where you can't really give a dollar amount. Pets can't enforce their rights in court. Wills are not sufficient. And once an owner's estate is closed, there's no mechanism to care for the pet. And who cares for the pet? Well, the probate is underway. So pet trusts are becoming more popular, and a lot of people are setting them up for their dogs and their cats and their horses and so forth. So I'm just mentioning that if you have pets and you want to make sure your pet is taken care of, if something should happen to you. Now, again, all trusts have to be funded to be effective. And again, I'm repeating myself but it's very, very important, because an unfunded trust is like a bank account without a single penny of deposit in it. Trusts can be funded with current assets. It can be funded with copyrights, trademarks. It can be funded with future assets like life insurance or retirement plans. The biggest mistake I've seen people make is they go to all the trouble of creating a trust and then they don't fund it. So I'm just advising you, if you create a trust, make sure you fund it with whatever assets you want to fund it with. Because if you don't fund your trust, the trust would have no effect on the assets that you had wanted it to affect. The trustee would have no management authority over your non-trust assets. The non-trust assets may not pass to persons or charities you want to benefit. Again, non-trust assets, we go back to the law of descent and distribution, where the state decides where your property is going to go. And it can be subject to claims of creditors or disinherited parties. Control of management of your copyrights may not pass to people who are qualified to manage them. And so, again, you have just make sure that you fund your trust if you create one. Okay, now here's where we get into copyrights and your heirs and beneficiaries. Are they capable of managing your copyrights? Because a lot of heirs and beneficiaries may not be knowledgeable about contracts and practices in publishing and, well, for example, publishing, or if you are fortunate enough to sell the audiovisual rights to your copyright, conflicts, or they may have conflicts between them as to the contract terms and offers and licenses or permissions. They may be wanting to generate income, whereas it might be wiser to protect the overall integrity of your work. For example, they might want to sell the property, sell interest in a copyright, one of your rights to the copyright for a short-term gain, whereas that might not be the wisest thing to do for the overall integrity of the work. So you got to question whether your heirs and your beneficiaries are capable of managing your copyrights. And then you also have to question, is your personal representative qualified to manage your copyrights? So you got to make sure that you got somebody who is knowledgeable and who can do that. Now, here's where we get into literary trusts. Now, there are several essential provisions. First of all, you have to name the trustee and the successor trustee. You have to name your beneficiary, and who can be you during your lifetime, and can be your children, your spouses, your family, whoever you want to, even a charity after you pass away. And you will identify the beneficiary and the shares you want to give each one. The duration of the trust is usually, the smart thing to do is for the duration of the copyright, and how the income will be distributed, and the dates or the conditions when the income might be distributed. The trustee's power, and again, now You've got to fund the trust. And with this, you have to identify your specific copyrights. You can't just put a clause in there that says, all of my copyrights. You have to put in the specific copyrights and name the copyrights specifically of what you have. And then you put in about, you give the trustee the authority to terminate the contract with third parties, as we said with earlier about termination rights. You might want to define your artistic vision so that the trustee understands what you want for your work and how you want your work to be exploited, and any criteria you want your trustee to impose on third parties to maintain your vision so that your artistic legacy lives on the way you would want it to be. Again, to appoint someone to do sequels or prequels or new editions. If you have continuing characters, you might want to have an author if you've got a popular character, especially like in a series of novels, like detective novels. You might want to have someone to continue your characters after you pass away and continue writing books with those characters, especially if there's a good market for them. And again, to identify new markets and technologies. And again, when you pass away, if you've left unpublished or unproduced works, you will probably want your trustee to try to market those and see if if a publisher would be interested in those. And then the next provisions is that you want to make sure that there's clauses in there for the removal of a trustee and a successor trustee, audits of the trust. Now you can also, if you want to appoint an agent or an attorney or a CPA or other experts, you can specify fees of the trustees, but you need to be careful of doing it on a commission basis, because you don't want to get a trustee who turned your copyrights in order to get commissions. And again, you can waive a bond in the trust if you want to. And the trust should be forward-looking because, again, remember how long copyrights and trademarks can last. So it shouldn't be just for today. It should be what might occur in the future. You can have more than one trust, and some authors might want to create separate literary trusts, especially if they write in different genres. For example, they might want to have detective stories in one trust or science fiction copyrights in another. If they write fiction and nonfiction, they may want to have different trusts for each. They might want to bequeath a single copyright to one beneficiary or a single genre to one beneficiary. Like, let's say, they write detective stories in science fiction. They might want to leave their copyrights to their detective stories to their daughter, and their sci-fi copyrights to their son. I mean, it's possible to do it. It can also create both revocable and irrevocable literary trusts. So there's a lot of flexibility there, and it's not necessarily for everybody. I mean, a lot of people may just want to do one trust, but it's just something to consider. If you work in different genres, or if you have different reasons for creating different trusts, which may be family or personal, or maybe you want to leave some of your copyrights to your family and some of your copyrights to a charity. Now, literary executors, who would also be literary trustees, no state law specifically empowers literary executors to act on behalf of authors' estates. Only the personal representative can manage the author's copyrights while the estate is being settled, unless the author has transferred his copyrights into a literary trust. And when the estate closes, the assets pass to the beneficiaries, and then they oversee the copyrights, again, unless the author has transferred his copyrights into a literary trust. And again, that raises the question of, are your beneficiaries capable of managing your property? Some may be. There are some beneficiaries of authors who do a great job of managing their inherited copyrights, and there are others who have no idea what they're doing. Now, so there's like I said, there's not very much law dealing with literary executors, not much in the way of guidance, and there are a few estate planners, and like I said, there are a few estate planners who know how to account for copyrights and other IP. And mistakes and misunderstandings can be costly. Even if you have a small estate, with a few copyrights of seemingly little value. So you have to be careful about what you're doing. Qualifications of your trustee has to be 18 years and older, should be trustworthy because copyright management is ripe for conflicts and self-dealing. I brought up the concept of somebody charting copyrights just in order to make commissions for themselves. And it's a time-consuming task. You have to be detail-oriented, to be honest and ethical. And it should be somebody who can understand your artistic vision. And it should be somebody who's knowledgeable of contracts in all the different areas in which your copyright can be exploited, like whether it's publishing, theater, motion picture, foreign rights, ebooks, so forth. The literary trustee is a fiduciary to the trust. I always recommend 2 trustees on the checks and balances system because it's good to have 2 people managing it at the same co-trustees so that you've got the checks and balances system and make sure that nobody is doing something they shouldn't be doing. And then you can also set up for the compensation of your trustees in your trust. Now, the literary trustee, that's, I said that it's ripe with conflicts. The literary trustee has to manage the copyrights to generate the maximum benefit to the heirs. But there's a little bit of a conflict there because the heirs are likely to be thinking in financial terms, whereas you might be thinking in terms of preserving your artistic vision and your legacy. So what does the literary trustee do when these are in conflict? So short term, it might be tempting to accept a deal that offers the most immediate income, but long term, would that deal depreciate the value of the property? So you can create a trust and you can be very specific about how you want your literary trustee to act. I've seen some literary trusts that are no more than 5 or 6 pages long, that are very broad and very general. I've seen some literary trusts that are over 150 pages long, in which the author went into every possible detail of what he wanted the literary trustee to do with his works. And, again, that's an individual choice to make, but it is possible to do that. So how do you do that? So, okay, let's say you create a trust by a written agreement, whether it's a revocable trust or an irrevocable trust. You have to sign and date the trust agreement. Again, fund the trust. And you transfer your copyrights into a trust by a written and signed instrument. And the transfer language has to be carefully drafted. And like I said, you can't just say all of my copyrights go into the trust. You have to specify your exact copyrights that you're putting into that trust. And then you should make plenty of copies with your original signature and date. Then the next step is that you record the transfer of the copyright with the U.S. Copyright Office during your lifetime. And the reason for doing that is to make a clear record that your copyrights now are in the title of the trust and no longer in your name. And you have to carefully follow the Copyright Office procedures, or else they might reject your transfer. Then the next thing is that you give a written notice of the transfer to your publisher, so your trustees and your beneficiaries can grant permissions and licensing rights. Also, you give a written notice, and this is a separate notice, of an assignment of royalties to your publisher. So henceforth, your publisher will pay your royalties to the trust and then eventually to your ultimate beneficiaries. The language has to be drafted carefully and precisely. The Copyright Office does not have specific forms for transfer, and the transfer instrument has to be drafted for a specific case. And if you fail to transfer the copyrights, then they'll become part of your residuary estates. So then they go through probate and contest, and then it's pointless to create a trust in the first place. So you need to go through all of those steps. Now, if you have subsequent copyrights, you can, after you've created the trust, you copyright it in the name of the trust instead of your own name. For instance, like prior to creating my trust, I copyright my book, My Apocalyptic Hemorrhoids, copyright 2021 by Charles Grippo. Subsequent to creating my trust, I copyright my new book, I'm Dead and You're Not, as copyright 2022 by the trustees of the Charles Grippo Revocable Living Trust. Very simple to do. And again, you just make sure that the copyright is taken out in the name of the trust. And that, of course, you can do that when you file your initial claim for copyright. Now, a pour-over will supplements your trust. The pour-over will covers property that's not included in the trust or other non-probate asset. It can be modified, it's amended, it's revoked anytime prior to the testator's death. Becomes irrevocable about death. Again, it has to be probated, it's public, it's valid only when the court says it's valid. It may cover copyrights and other IP, although that's not always desirable to do that. Again, you're better off if you can put everything into your trusts, if you're going to create a trust. So let's go back to Jack and Jill and the Ghost of Elsinore Castle. And because many of you are collaborators, you've collaborated with other authors, so you need to know about the additional issues that you might be facing. As joint authors, Jack and Jill share the copyright ownership of the Ghost of Elsinore Castle. Jack passes away on March 22nd, 2022. He leaves his share of the copyright of the Ghost of Elsinore Castle to his adult children, Ophelia and Laertes. Jill survives him. Now, as playwright, Shakespeare comes along and he wants to turn the Ghost of Elsinore Castle into a stage play. Jill likes his ideas, she likes his offer, and she thinks he'll preserve the integrity of the novel. But Ophelia and Laertes insist on getting and accepting an offer by the Kardashians to turn the Ghost of Elsinore Castle into a rap musical, in which they will play all of the parts except for Hamlet, who will be played by a talking horse named Mr. Ed. Jack and Jill never entered into a written collaboration agreement. And remember, Jack's children are beneficiaries, and they have equal ownership of the copyright with Jill, and therefore they have the equal rights to make the decisions. So who decides which offer to accept? Now, we can go into the same facts, except they have entered into, Jack and Jill have a written collaboration agreement before they wrote a word of the book, which, by the way, is the right way to do it if you're going to collaborate with anybody. Have a collaboration agreement before you do any work together. And their collaboration agreement permitted each of them to plan their respective estates, which is great. Jack leaves his share into a literary trust, and he appoints his agent, I. Jipham, as trustee of his literary trust. Jill hasn't yet planned her estate, but she's alive and she survived Jack. Jipham wants to accept the Kardashians' offer for the Ghost of Elsinore Castle, which he believes will bring maximum benefit to Ophelia and Laertes and put a fat commission in his pocket. But Jill still stands by Shakespeare's offer. And so their written collaboration is silent on the means to resolve disputes between the authors' estates. So who decides? So the solution is that in your collaboration agreement, make sure that you have a mechanism for each of your estates and your estates to resolve disputes. And I'm going to leave you with a question here, that if you have collaboration agreement with your collaborators, what does your agreement say about your respective estate planning rights and resolving disputes if they occur between your estates? Okay, now your trustees, your trustees and designees should be persons above the age of 18 or older. They should not be incapacitated or otherwise unable to serve. Make sure they are qualified to serve. In other words, they're expert enough in the duties in which you're entrusting them. And you should ask each person if they're willing to serve, because you don't want to designate somebody and then the person doesn't want to do the job, because it can be time consuming. And it does take a lot of work. And so some people may not necessarily want to do it. You can specify the approximate fees in most documents. It should be a person you can trust, again, successor trustees. And you can designate different persons for different duties. You can also designate professionals like banks or trust companies or attorneys, but just make sure that whoever you designate, again, is experienced in IP management. There's other kinds of trust, and I'm just going to mention these because you'll probably hear about them. And I'm not going to go into them because this could be a separate webinar by itself, but there's charitable remainder trust, there's an AB trust, there's subchapter S, intentionally defective trust, Alaska trust, which despite its name is not just for people in Alaska. There's a complex trust. There's an able trust. There's a qualified terminal interest property trust, called, which is sometimes known as a Q-tip. There's a qualified personal residence. There's an asset protection, and there's a spendthrift. And that list is not all inclusive. There are many, many other kinds of trusts. But I'm just mentioning them so you, because you'll probably hear about them if you continue to think about your estate planning. So here's a quick review. These are the suggested documents for authors. Doesn't have to be for everybody. A living trust is revocable or irrevocable for your non-IP assets. Other trusts, if needed, like I said, a pet trust or some of those others. A certificate of trust is a document that basically says that the trustee has the power to manage the trust for you. And it's just a document that the trustee can give to third parties, showing that he has the authority to act for you. Again, the digital assets, don't forget your digital assets. Literary trust for your copyrights. Power of attorney for healthcare, power of attorney for property, and pour over will with or without testamentary trust, the transfer of copyrights, the notice of assignment of copyrights to your publisher, your agent, and any other appropriate third parties, the direction to pay royalties to the trust is given to your publisher, again, that you give to your publisher or your agent or whoever would normally be paying your royalties. And then the declaration of the living will and the disposition of anatomical remains. Those are the suggested documents. Again, everybody doesn't have to have those. I recommend them as a good plan for everybody, but it's an individual choice. And okay, now, if you have any questions, you can email me at my email, and please use the subject line Authors Guild. And the reason for that is because I get tons of emails all the time, and a lot of them, just look like marketing and scams and things like that. So if you use the subject line Authors Guild, then I'll know that you were part of this webinar tonight. Also, if you do have questions and you want to contact me, please understand that I will only answer general questions. We're not going to create an attorney-client relationship by you simply asking me a question. If you want to create an attorney-client relationship, we can talk, but that's not going to happen just because you asked me a question. Like I said, if you do have specific questions, you should talk to an attorney about your own personal estate. I do also, I have a blog in which I publish articles about estate planning and copyrights and information for legal information for authors and playwrights. And you can visit the blog, and you can also subscribe to the blog. You just go on one of the blog pages, and over to the right side there is a place where you can just subscribe to the blog, and then you can get the blog entries as I make them. And so that's pretty much all I have. I know there have been some questions. I don't quite know, to be honest with you, I don't know how to use this to answer questions here. I wish I could, because I'm not all that qualified here to use this to answer questions. But I will try here. Let's see. Somebody asks, is it preferable to hire an estate attorney in your state? Well, yes, it would be best to hire an estate attorney in your state, just because most state laws are fairly uniform, but there are differences between the states within the laws. So it's probably best to hire somebody who is an estate planning attorney in your estate rather than to hire somebody who's not in your state. Plus, which attorneys are also bound that attorneys can only practice in the states in which they're licensed to practice. So, it's probably best to do something like that. Do I handle contracts for feature films and screenplays? Yes, I do. I do handle that. Let's see, I'm going to see if I can see some of these other questions that people have asked. Again, I don't know if I can't. No, I'm not doing too well here. Let's see. Do I handle contracts? Yes, I do handle contracts. Cheryl, hello, how are you? You and I have not met, but I do have to say hello to you from a friend of yours, Jeffrey Sweet.
Oh my goodness.
Jeffrey is a friend of mine, and
Oh,
he and I just had a conversation last week because Jeffrey is a playwright, and
yes,
and I've known him for decades. And I mentioned to him that I was doing this program and that you were going to be involved in it. And he said he knows you, and he said to say
very
hello.
well.
So I'm saying hello. Sorry.
Thank you so much. And
You're
I'm
welcome.
very overdue to catch up with Jeffrey.
Okay. Okay. If you don't get your copyrights changed during your lifetime, will they be covered by the pour over will? Yes, they would be, but do you want them to be covered by the pour over will? Do you want them to go through probate and all of that, or would you rather have them just be not have to go through all of that administration and possible delays and expenses and all? So, and it's a personal choice. I mean, yes, you can, but I would suggest not to. Does the durable power of attorney handle the guardian issue? Well, I went through power of attorneys earlier, and I think that the power of attorney kind of, the power of attorney does cover the guardianship issue rather than have the court do it. Although under some circumstances, the court may still have to get involved. Let's see. Will this be available, or will the video be archived anywhere? I believe that the Authors Guild is recording it. I don't know or not. And I don't know, we haven't really talked about this because, to be honest with you, I'm going to take this material, I'm going to turn it into a book. So I don't know. I'll have to discuss that with the Authors Guild.
Yes.
But because to be honest with you, I've already started on the book. I haven't talked.
That's wonderful.
I haven't talked to my publisher about it, but anyway.
Maybe you'd care to write a blog piece or something like that for our website.
I would be more than happy to. I'll be glad to talk to you about it, Cheryl.
Great.
Anyway, I think that's all the questions we've got. Right? Oh, we have another new message. Well, thank you, Charles. Lots of content to consider. Well, I hope you do. And the one thing I'm going to recommend everybody is don't postpone estate planning, because we know that things can happen. I mean, I hate to say it, but you could be here today and tomorrow. Mm-hmm. We know what can happen. Oh, Barbara, yes, say hello to your husband. Say hello to Hank for me. Yes. Mm-hmm. So I'm just going to recommend that you don't postpone estate planning, because it can happen. As I told you, a friend of mine, I just found out this week, 51 years old. He's in the early stages of Alzheimer's. Mm-hmm. And so, things like that can happen even for people that are that have many years of lifetime ahead of them. But unfortunately, those things happen. And of course, we saw with COVID that many people passed away, unfortunately, through that. And I had a couple of friends who passed away from COVID too. So anyway, so I think that's it. So I think I'm going to end it right now.
Charles, if I could just toss in a brief word. Hi, everyone. I am currently invisible because I have somehow turned off my camera. Cheryl Davis.
I know. I have a problem with this too.
I'm the general counsel of the Authors Guild, and I want to formally thank Charles so much for putting together this wonderful program. We're very grateful to him and to you. And should you have any more general questions of the Guild, please do feel free to reach out to us. We are literally here for you.
And I also want to point out one more thing that I did get a chance to mention during the estate planning. I did mention that if you have favorite charities, you might want to remember in your estate plans. I am going to highly suggest remembering the Authors Guild in your estate plans, because any help you can give the Authors Guild helps them to continue serving us. So, and future generations of authors. So if you want to do something in your estate plan for charities, please put the Authors Guild at the top of your list.
And we do also manage estates for
that's true.
Some people.
Correct. Yes,
so,
you do. That's right.
But thank you again, Charles.
Okay, well, you're welcome. And okay, then I think I guess we'll just end it now. I'm not quite sure how to do this, but okay.
All right.
All right. Goodbye, everyone.
Goodbye.